So the rule of law, it protects human rights, as I said. It requires the independence of the judiciary. It requires that the state should not be able to interfere with the rights and liberties of individuals other than in extreme situations. I'm not going to go through all this. I've got quite a few slides here, which I could go through. Obviously, it's reinforced by the Universal Declaration of Human Rights 1948. I'll read this bit out. It is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights are protected by the rule of law. It's enshrined in English law. It's enshrined in EU law, of course. Leading European Court of Justice decision, a community based on the rule of law, inasmuch as neither its member states nor its institutions can avoid a review of the question of whether the measures adopted by them are in conformity with the basic constitutional charter of the treaty. The Treaty of the European Union is founded on the principles of liberty, democracy, human rights. The treaty demands that prospective members such as Turkey respect the rule of law. The Treaty of Nice allows for suspension of existing members in the event of its breach. Now, I was at a seminar last week where the British ambassador to Greece spoke, and he mentioned that, of course, we got on to Turkey. And their approach, of course, and he said there was a Greek approach as well, is an approach which he described as yes, but, not no, but. Yes, we want you in the EU, but we'd like you to change, please. Not no, you've got to change first. And of course, that is extremely revealing that, again, this is what we're up against. We are politically expedient in Cyprus, unfortunately, because we are not very powerful. We are small. We're not as important. Now, have all these cases been successful? And I'm going to go through that. The other thing I want to do, and I think lawyers do this, and we try and do it all the time, is remind, again, as I said before, remind ourselves of the legal position. We mustn't forget the Security Council resolutions. You know, that they were issued, there was a meeting, they were issued, and they are legally binding on the United Kingdom not to recognise the TRNC. I'll read out Resolution 541. The United Nations Security Council deplores the declaration of the Turkish Cypriot authorities of the purported secession of part of the Republic of Cyprus, considers the declaration referred to above as legally invalid, and calls for its withdrawal. The United Nations Security Council calls upon all states to respect the sovereignty, independence, territorial integrity and non-alignment of the Republic of Cyprus. It calls upon all states not to recognise any Cypriot state other than the Republic of Cyprus. Resolution 550, 1984, reiterates the call upon the states not to recognise the purported state of the Turkish Republic of Northern Cyprus. This is legally binding on the UK. How many times do we hear that in the community? Well, how many times do we hear that in the House of Parliament when we go and see the MPs? How many times do people explain that to anybody? I'd like someone to tell me that, and I think I know the answer. The Treaty of Guarantee, the Treaty of Establishment, that's the law. That's what we compromised in 1960. The Treaty of Guarantee, the Treaty of Establishment. Let me read you Article 2, as we all know it. The Treaty of Guarantee. Greece, Turkey and the United Kingdom recognise and guarantee the independence, territorial integrity and security of the Republic of Cyprus. The United Kingdom undertakes to prohibit any activity aimed at promoting directly or indirectly partition of the island. Now, sometimes people say, well, some of these cases haven't been successful. We can talk about the Mobilos later on. Obviously, Apostolides was a great win for us because it upheld our rights in the EU to our land against illegal trespassers. I'm not really going to go through all these cases and go through all the principles. What I wanted to really give you was my flavour of why it just seems so obvious to me that the law and lawyers have helped. I'll give you another example. When we were working on Apostolides, we lost the first case. It was a bad judgment. It was a pathetic judgment. We lost it. We appealed it. Obviously, many on our side were very concerned because we're not doing this because we've got egos, some of us may have, but we're doing it for Cyprus, a lot of us. It's difficult to believe that, but that's true. And the President of Cyprus President Papadopoulos at the time, told my good friend Costas Frangeskides, who was extremely concerned when we lost the first case, not to be concerned. He said, what you've done at a minimum, you've stopped them for 3 or 4 years building. And then we won the Court of Appeal. So I just want to give an example that even there, if we hadn't done anything, if we'd let them have free rein in Cyprus, they would have concreted Cyprus by now, in my view. So, going back to the question, obviously the law alone cannot solve the Cyprus problem. We cannot have a military solution. We cannot remove by force Turkey's army, and there is no will in the UN to do so, as they did elsewhere. We know the hypocrisy that goes with all of these international issues. But what we can do as lawyers, and we have done as far as I'm concerned, is not only remind people about our rights, the rights of the Greek Cypriots, the rights of all Cypriots, but also give ammunition to our politicians who desperately need it to redress the balance with Turkey. But sometimes I do feel that our politicians get a little upset when we succeed, because it sort of affects them, affects their position. I don't know if I'm right about that, but I do get that impression sometimes. I'm sure that's not true. So I think overall, it's important that we have stood up for our legal rights. We've made it much more difficult for the UN and Turkey to push us about. We also remind people of the downside. And as we did at the time of the UN plan, I and Lobby commissioned an opinion from a leading barrister as to what would happen if we signed the Annan plan. And a lot of people didn't realise that if we signed the Annan plan, it was likely that our rights to apply to the European Court of Human Rights would be extinguished if, in a plebiscite, we voted for it of our own free will. So I think we've redressed the balance. I think overall we had to do what we did. I have to answer the question in the negative, but in a positive vein. And I hope I've hopefully prompted some questions. Thank you.
Thank you very much, Costas.